Morning, everybody. Thank you for joining us. Let me say at the outset that this is a process. This is the beginning of a long process of understanding what these federal laws and the expanded unemployment insurance laws actually mean and how they are to be implemented. So we don't have all the answers, but we've done some analysis, which is a good start. So please bear with us. We anticipate having additional webinars in the future, in the very near future, as new information is shared from the federal and state governments, as well as from our own experiences as advocates for employees. Please try not to ask questions about your specific situation at this point. When we're done with the webinar, we'll have time to deal with individualized questions. We want to spend the time giving everyone an overview and making sure that everybody has a good foundation for understanding what these benefits are all about. There is going to be 4 topics that we're going to cover today. The first is going to be unemployment updates, and Rachel Cole, who is the director of the University of Michigan Workers Clinic, will be the presenter of that. We're going to talk about the new Federal Emergency Leave Act, and that's the Emergency Family Medical Leave Act, and Robin Wagner from Pitt McGee is going to cover that. I'm going to cover the new Federal Emergency Paid Sick Leave Act, and Kevin Carlson from the Pitt McGee firm is going to cover the gray areas in the law so we understand where the issues are to be interpreted going forward. And Beth Rivers from the Pitt McGee firm is going to also talk about strategy going forward. And I see that Heidi joined us, Heidi Sharp, and I think she may have some comments about essential duties, whether employers can require employees to come to work claiming they're essential workers, and also some ideas about small businesses and how they might react to this. So Rachel, I'll turn it over to you to talk about the unemployment updates.
Sounds good. I'm going to share my screen because we've prepared a PowerPoint on this. Let's see here. That doesn't seem to be on the screen. Let's see. Can everyone see it now?
I got a weird, the PowerPoint's not up on my screen.
Let's see.
It was up before.
It was up before.
Now it's a spreadsheet.
It's a spreadsheet.
Oh, don't look at that. That's my spreadsheet of all my policy projects for my students. All right, it's up now. Everyone can see it?
Yeah.
Excellent. All right, well, so let's first start with the state unemployment changes. So the biggest one per executive order is that the amount of weeks have expanded from 20, which is normally what we have per statute. We used to have 26 in Michigan, but in 2011, the legislature amended the statute to remove that down to 20 weeks. But per executive order right now, the governor has expanded it back up to 26 weeks. One important note here is that anyone with an active benefit year, let's see. Anyone with an active benefit year, did the screen change?
Yeah, you went back to the first slide.
All right, we'll go from here. Anyone with an active benefit year. So that means that if you filed for benefits and you have already collected maybe your full 20 weeks of this year, and you are now unemployed again, you are not exhausted at this point because you have this additional 6 weeks from the governor's executive order. And then there's also some federal extensions that we'll get into a little bit later. I've been told that the agency is going to do a sweep of all people that have filed for unemployment benefits since January 27th to see if there are any additional weeks that you are eligible for, and they will let you know. However, you are also able to log back into your MyWAM account and reopen your claim to see if to be able to get these additional weeks. So that's an important benefit to be aware of. Another big change is that the strict compliance with some of the disqualification and eligibility provisions are lifted right now per executive order. You don't have to search for work. You don't have to go in person to Michigan Works to register. And we'll go into a little bit some of the changes with a leave of absences. Normally, if you are requesting a leave of absence, you are considered unemployed. But the governor has changed that right now for certain COVID-related reasons and childcare responsibilities. And also, if you have to leave work due to COVID-related reasons, that's also been expanded for you as well. So we'll get to
Hey,
the next
Rachel,
slide.
can you just hit the resume slideshow button on your screen there? Should be right. Yep.
When I did that, it went on my other monitor,
Oh,
and
that's
so I
Okay.
don't know how to make it go back.
Okay.
Um,
Never mind.
I
Sorry.
can make it bigger if that helps.
No, it's fine. It works. Sorry to interrupt. Go ahead.
Is that any more helpful?
That's fine how it is. Sorry. Go ahead.
All right. So getting into leaves of absence and unemployment. So if you have requested a leave and you've done so because you need to self-isolate or self-quarantine, you have to care for somebody who has been diagnosed with COVID or have had contact with someone with COVID in the last 14 days, you are able to request a leave of absence and be placed on leave and obtain unemployment benefits at the same time. If you also have other family care responsibilities due to a government directive, meaning that schools are closed and you have to care for, or your preschool is closed due to the stay-at-home order, you have the ability now to obtain unemployment benefits and request this leave. One thing to note here, if you're already on sick leave or if you're receiving disability benefits, you might not qualify here. However, another question that we've been getting a lot of is whether if the employer is placing me on leave, placing a claimant on leave, can they obtain unemployment benefits? Per the statute, that's always been okay. If you are being placed on leave by your employer and you are not receiving earnings, you are able to get unemployment benefits because it's not at your request. The change was because of the executive order, because normally if it's your request to be on leave, you're not entitled to benefits. But if the employer is placing you on that leave, you are entitled to benefits, assuming your earnings don't offset anything that you actually receive unemployment benefit wise. And we'll get into underemployment in a little bit. So we're moving over here to the fully paid leave. If your leave is fully paid, then you don't receive any you're not eligible for Michigan's unemployment benefits. You're not eligible for the federal unemployment because you're not actually considered to be unemployed at that point. However, if you're partially paid during that time, it's possible that you might be considered underemployed and you might be able to receive a reduced unemployment benefit from Michigan. And it's unclear right now, but it's possible you might also be able to receive the federal unemployment benefits that have recently passed. Finally, if you're on an unpaid leave, you're considered to be fully unemployed. You can get the full unemployment benefits from both the federal and the state government. So looking quickly at the updates on the federal unemployment expansions, I want to point out that NELP has created a great review of this federal legislation, and I placed the link in here as well. It does a great job. It's a 3-page article that breaks down the changes to unemployment benefits. So the first one is the pandemic unemployment compensation. This is a bonus on top of your state weekly benefit that you would get. So if the max in Michigan that you can get is $362, depends on how that number is calculated based on how much you've earned over the last benefit year. So you might not be entitled to that full $362 depending on your earnings, but the most you can get in Michigan is $362. And that would put your max total per week is at $962 per week, because you'll get an extra $600 per week for the federal government. For another part of the CARES Act is that there's pandemic emergency unemployment compensation that further extends the amount of weeks that you can receive unemployment benefits. So It used to be 20 in Michigan per statute. We have now the extra 6 weeks from the governor's executive order, and now you have another 13 from the federal extension. One important note is that if you are receiving paid sick time or sick leave, it's unlikely that you'll be able to receive any of these federal benefits. And also, if you are able to work remotely and you are working with a full pay, it's also, you are not entitled to these benefits. Those are very explicit in the Act. Finally, this part's very exciting. It's the pandemic unemployment assistance. This covers people who are not normally covered in Michigan to receive unemployment benefits. This part is very exciting because it helps both people who are self-employed or independent contractors be able to receive some assistance during this time. Because one important thing to note about them is that when their work goes to zero, like if they lose their work also goes to zero as well, and they're not caught by the normal security net that we have, but this catches them. Also, part-time workers in Michigan, if you aren't looking for full-time work, you're not eligible to receive unemployment benefits. And so part-time workers now are able to receive the pandemic unemployment assistance. So that's a great benefit as well. And then finally, we've been receiving a lot of people that have been denied at my clinic that have been calling saying they've been denied because they did not earn enough in their benefit year. There is a specific formula to determine whether or not you are eligible for any benefits in Michigan. And you do have to earn at least in 2 quarters and a little bit shy of $4,000 in at least one of the quarters. It's a complicated formula because then you have to also have earned 1.5 times that highest weekly benefit amount. Don't worry about any of that, because fortunately, if you weren't covered under the state UI, you now can be covered under the pandemic unemployment assistance program. You have to show that you're either fully or partially unemployed, or that you are unable to work due to a variety of reasons. This is a non-exhaustive list that I put here, but it's a pretty long list of options that can show whether or not you would be entitled to pandemic unemployment assistance. And this is the same payout from the federal government of the $600 per week. Plus, you'll be entitled to 1/2 of the state's average weekly benefit amount, and that's amount that's to be determined. You might be able to get more, but I'm not sure at this point how that's going to be interpreted because we haven't received any Department of Labor guidance on that just yet. Moving on to underemployment. So this slide also doubles, if you see it as a reduction in pay, is also maybe pay on leave is something that we can go either way to talk about that. And so one thing I want to specifically mention here is that if you are earning any money while you are claiming unemployment benefits, you have to report that to the agency, and you have to report it in full. This is part of your responsibilities. You certify every 2 weeks for all the weeks that you would like to claim, and you have to do this. And if you don't do this, you could be subject to fraud charges. And so I want to just be very upfront with that. That's very important for you to do. I put 2 different hypotheticals on here for work share employers and non-work share employers to kind of highlight the importance of work share, because I'm going to be talking in a few minutes about some things that you can encourage your employers to do. And one of them is to be part of the work share program, because you might be able to get more benefits because of it. So typically under this first table here, if your weekly benefit amount, let's say, is the $362, and you've been reduced to $700 a week, right now, because you're $362, 1.5 times that is $543. Because $700 is more than your weekly benefit amount, you would not be entitled to any Michigan UI, which means you're probably not entitled to any federal UI either. UI is unemployment insurance. But under the workshare program, you would be able to at least obtain Michigan benefits. You might not be able to. It's unclear right now. The Department of Labor hasn't issued guidance on whether work-share employment, that's called short-term compensation employers, if that's going to be covered or not with the extra benefits. It seems like it might, but it's unclear, and we'll have to wait for Department of Labor guidance on that. So I'm not going to go into all this, but I'm happy to explain it to anyone that would like me to kind of talk about the math. But there's some different formulas to talk about how you will, how much benefits what your weekly benefit amount would be, what your reduced payment would be, depending on your earnings. There's different calculations depending on how much you've actually earned. All right, so some helpful advice that you can share with your employer is right now, if your employer has to place you on a leave, or if you request a leave, or if you're laid off during this time, it's not chargeable to the employer. Normally, employers have to pay taxes, and their experience rating of how many people file for benefits, unemployment benefits, will go up the more people that file, which means that they're going to be paying a higher rate of taxes for all of their employees going forward. However, right now, during the governor's COVID-19 executive order on unemployment, employers are not going to have to pay into this. It's going into the non-chargeable fund, so they're not going to be negatively affected by you drawing unemployment benefits. This is a huge benefit, so employers and claimants alike can work together here to negotiate a leave of absence for you, or to figure out how they can maybe temporarily lay you off if they have to, with the hope that they can bring you back later. I also highly encourage employers to look into the work-share program. The governor has expanded the employer's eligibility here, and you have to apply on MyWAM. I've attached some fact sheets and some other information about how employers can apply. But as you can see from the prior slide, which we'll share, the benefit to the employee is more, because employees will receive all of their employer's benefits, meaning that if you have medical, dental, any other 401k, the employer will maintain that. You'll still have job security. But on top of that, you'll also be able to get paid with unemployment benefits during this time. And that's a very big benefit. Also, if your employer is struggling, there's a couple other state programs. I would place some other links here about some other state programs that will help. So here's some just general unemployment review from the amount of questions that our clinic is receiving. I know it's hard to apply right now. The website went through a major overhaul this weekend, and so hopefully you'll be able to apply and log into the best way is to apply online. Just keep trying is my best advice on that. And really limit the amount of times that you call the agency right now. They are overwhelmed with calls. I believe at least one point last week, there was something like 69,000 calls that happened in one day. The agency has only about 600 employees. There's no way they can handle all of those calls. So they've also set up a schedule if you have to apply online. So I encourage you to look that up. It's based on your last name, which days that they would like you to call. It's trying to limit the amount of calls that come in each day so that they are able to obtain and process these claims. If you're having a hard time actually getting through and completing your application, you normally only had 14 days to apply for benefits and receive it from your start receiving benefits from your last day of work. But because of the governor's executive order, that has been extended now for 28 days. So you have a little bit longer to file. There's also a lot of concern about whether or not you should leave your job if you're feeling concerned about the safety of it. Remember that your employer is in a new boat with you here too. This was not something that they anticipated having to deal with. And so work with them to try to figure out if there's a solution to make you feel safe at work, to make sure that your employer can try to do what they can do. And one thing here, if you do leave your job because of this, you have to be reasonable. That's what the court's going to look at if your claim gets denied, is whether or not you were reasonable in leaving at this point. And so the more you can do to show that you've tried to work with your employer, the more reasonable you're going to look. And also, I would also encourage you to try to get a leave of absence before quitting, because right now with a leave of absence, you could be entitled to the same benefits, and you have other benefits there. You're worried about maybe you've been deemed essential, but you're not sure. We'll talk a little bit more about that later. I think other people are going to talk about it, but here's an email account that apparently you can go to and ask questions about it that I found. And if you feel like you've been misclassified, if you've been deemed an independent contractor by the agency, but you are actually an employee, I encourage you to call my clinic at 734-936-2000 to let us know, You should also appeal that with the agency. Everything that you can appeal can be done on your MyWAM account, and that's probably the easiest way. But if, and I would also encourage you to seek other legal advice on the if you've been misidentified or misclassified. Or if the employer has misreported your wages, that's also something that we would like to see if there's something we can help you with there. With that, I turn it over to Robin.
Let me add, this is Michael. Before Robin starts, the PowerPoint is awesome. It's fantastic. Rachel did a great job, really informative. And this PowerPoint is going to be made available to everybody who's a participant on this webinar. So Steve Pantoni from MAJ will make sure everyone has access to it. So go ahead, Robin, you're up.
Thank you, Michael. And thank you, Rachel. That is just such an incredibly rich bit of information there. So now we're going to talk about the provision of the Family First part legislation that was enacted in the middle of March 18th, and it goes into effect next week. There's some debate about exactly when. The U.S. Department of Labor is this week, later this week. How time is flying. The U.S. Department of Labor has issued some question and answers that say it's April 1st, even though the legislation itself had said that it would be enacted on April 2nd. So again, Kevin is going to talk about gray areas. I guess that goes into the category of gray areas. The Emergency Family Medical Leave Act adds an important benefit for one kind of employee, and that is an employee who has a child that has, or children that have lost their care, their school or their care provider. But to be eligible, it needs to be for someone who has an employer with 500 or fewer employees. Now there's a big asterisk there. Coming in April will be Department of Labor regulations that may create limitations or exclusions for employers with 50 or fewer employees. But that regulation, that activity hasn't been issued yet. So for now, it's anyone who works for an employer of 500 or fewer employees. And you have to have been working for 30 days prior. A big question on this and a disappointing answer is that if the employee has already needed to access these benefits or has been laid off, no longer works there because of the slowdowns that have happened throughout March, they're not eligible for this benefit. And if you are a healthcare provider, an emergency responder, your employer has the discretion to decide whether you can take this leave or not. But if we could go to the next slide, please, Rachel. Oh, there you go. What you would get is 2/3 of your regular rate of pay, starting on the 11th day of a up to 12-week leave. Now there's some caps to that. It's capped at $200 per day and a total of $10,000 you can be receiving over the course of those 10 paid weeks of leave. The first 2 weeks are unpaid, but as we'll discuss later on, there are other benefits that you may be able to take advantage of for that 2-week first period, including the Emergency Paid Sick Leave Act or any accrued time off you might have. The qualifying need, again, this is really different from the regular FMLA. It's only if you're unable to work or telework because you're caring for dependent children who've lost their child care or schooling. So that's a key thing to remember about this. If we can go to the next slide, please. Okay, so there are some responsibilities we want to keep in mind here, and this echoes something that Rachel said as well. There's an importance here in trying to communicate effectively with your employer. So if you have this leave and it's foreseeable, of course, at this point, everybody's had their children be out of school for the foreseeable future. But nonetheless, you need to make a timely notice of your intention to take the leave. For instance, if you have a small child who's been in childcare and now all of a sudden faces a situation where your childcare provider has to shut down. The more detail you can provide will be the better for everyone. Names of the children, which school or childcare provider, etc. Your employer's responsibilities will be to protect your job. There's some asterisks about what protecting your job looks like. If at the time you come back to work, your employer has at least 25 employees, you will be able to have your own job restored. If they have fewer than 25, you might not, but they're supposed to try really hard to get you back into a job once they can. They have a year. There's a long sentence there. So there's a period of a year where if your employer has an opening, they have to consider you, but they're not required to hire you. So again, when you come back to work, there's some job protection. Over 25 employees, better. Under 25, some job protection, but not as robust. The next slide, please. Thank you. So this expansion act for the family medical leave works as a supplement to your FMLA rights. So as most everyone on this call knows, if you were already eligible for the Family Medical Leave Act, that means you would have already been employed for at least a year and to have worked at least 1,250 hours for that employer in the previous year. And your employer would have to be of a certain size threshold. It's 50 or 50 within a 70-mile radius. There's some thresholds about how that's considered. But then you would be able to take a total of 12 unpaid work weeks of work. And the expanded eligibility means it could be for your own serious health condition, for the birth of a child, for adoption placement, or for the need to care for an immediate family member, a spouse, a child, or a parent with a serious health condition. So this is an expansion which allows some kind of job protection over 12 weeks when it's a child whose child care has disappeared, is the emergency family medical leave expansion piece. A key difference is that the Family Medical Leave Act guarantees continuation of your medical benefits. It's not clear that the Emergency Family Medical Leave Act would expand that. Another thing is, and this came in as a question on the board, of what happens if you're a public employee. A public employee under the Family Medical Leave Act, if you are employed by a state, a municipality, a territory of the United States, a township, things like that, the answer is probably yes, you are entitled to this EFMLA. However, if you're a federal employee, it's unlikely that you are. That hinges on the structure of the Family Leave Act itself, and the act, this EFMLA only amended Title I of the FMLA, and the federal employees are covered by Title II of it. So there's some exceptions to that, but unfortunately, federal employees don't have the same coverage of this act. That was to answer a question that came in online. May I see the next slide, please? Oh, that was the end of the family medical leave portion. So if there are some additional questions, put them into the chat. We'll see if there's time to address that.
Next slide. Okay, so the related federal benefit that was enacted on March 18 and becomes effective on April 1st is the Emergency Paid Sick Leave Act. And again, it's you're covered if you work for an employer with less than 500 employees. As Robin pointed out, there is some issue as to whether there is coverage for employees working for an employer with less than 50 employees. The current question and answer sheet from the Department of Labor suggests that the employer has to ask for the exemption, that the employers are encouraged to document why providing these benefits could interfere with the survival of the company. It's a fairly high bar they have to meet, but it appears at this point, and this is a gray area that's going to be fleshed out, that it's the burden of the employer to establish the exemption. So we encourage everyone who works for an employer who has less than 500 employees, even those who are working for the smallest of those employers, to consider themselves covered for this benefit. The qualifying conditions are much broader than the qualifying conditions that are found in the Emergency Family Medical Leave Act. And you can see from the slide, there essentially are 6 conditions. Whether you're subject to governmental quarantine or isolation related to COVID-19, whether you've been advised by a healthcare provider to self-quarantine, whether you are experiencing symptoms of COVID-19 and pursuing a medical diagnosis, and then whether you are caring for an individual who is subject to an order, whether you're caring for a child who has been out of school or lost the care of their child care provider, or there's a catch-all, you are experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and the Secretary of Labor. Next slide. Some employees are exempt. If you work for a employer of agricultural workers on small farms, if you're a seasonal employee, some domestic workers, some babysitters are exempt from the coverage of the law. You also, your employer has to be either a public or private enterprise that is engaged in commerce or in an industry or activity affecting commerce, a pretty broad description. Most employers will be covered, but it's something that you need to be mindful of. Next slide, please. So how much are you going to get? You're going to get your regular pay, or the federal minimum wage, whichever is greater. There is a cap at $511 per day, or $5,100 in the aggregate. If the sick leave is because of your own sickness or your own need to self-quarantine, $511 per day means that you probably are going to be making about $127,000 per year. And if you are over $127,000 per year, you'll be capped. Otherwise, you'll be able to get your full pay. And then there's a second tier. If your condition is to take care of other folks, then you're capped at $200 per day, or $2,000 in the aggregate. Next slide. So the statute specifically says that your employer cannot require you to find a replacement in order to qualify for the paid sick leave. And the law also provides that you may use other employer-provided benefits at your option, not the employer's option, but Congress gave you, the employee, the option of selecting which benefit package you want to go with first. You can go with your employer's package, or you can go with the emergency paid sick leave package. It's at your option. There is no specific application process that's built into the law. Beth Rivers is going to talk about strategies, but for the most part, you are going to be simply asking your employer to provide these benefits. So keep in mind that the benefits under the Emergency Family Medical Leave Act or the Emergency Paid Sick Leave Act are benefits that are paid by your employer to you, unlike the unemployment insurance benefits where you go to the agency. In order to get these emergency family leave benefits or emergency paid sick leave benefits, you have to go directly to your employer. And that is going to create a series of issues. I'm sure communication is going to be somewhat limited because most companies today are either not functioning or function in a limited capacity. But you're going to have to pursue those benefits through an application process that's going to be provided by your employer. Kevin, you want to talk about the gray areas? Is he up? I think Kevin has fallen off.
Yeah, thank you. So, no, I'm here.
Oh, okay, great. Oh, hi, Kevin.
So, yeah, hi, thanks. We've highlighted some gray areas. This list is by no means exhaustive. Given the fact that the law has not even taken effect yet, we've got no experience or case law or interpretation by the Department of Labor to help answer some of these questions yet. So we're kind of trying to predict what some of the open-ended or gray areas might be. The first one is whether or not paid sick leave benefits and family leave benefits are taxable. All indications in the language of the statute is that, yes, they are taxable. The withholding amount may be a little less than a normal paycheck because the statute does speak expressly to exempting paid sick benefits or paid sick leave benefits from the employer portion of Social Security tax. So taxes will likely be withheld from these checks, although probably not in the full amount of a normal paycheck. Rachel, could we go to gray area number 2? We don't know yet what category number 6 of EPSLA eligibility will mean. It says that employees are covered if they are experiencing any other substantially similar condition. Presumably that means conditions that are substantially similar to COVID-19. The federal agencies responsible, Health and Human Services, Treasury, and Department of Labor have not yet issued any guidance on what this will be. And we also don't know what the process is to apply for coverage other than submitting some kind of information to your employer telling them what your diagnosis is, what the prognosis is, and what the course of treatment or inpatient care is likely to be, which is exactly what you would have to give to the employer under the FMLA as well. So this is a standby area and wait to see how it develops. But as a practical matter, employees should do what they would do when they request FMLA leave, which is preferably communicate with the employer in writing with supporting documentation from your doctor or healthcare provider, telling them what the diagnosis is or inpatient medical care might be if those things are in place. Gray area number 3 is how do we know if your employer is covered? I've already spoken with clients this week who have had employers telling them we are or are not covered because of COVID-19 or fewer employees. This is all domestic United States workers, including employees who are on leave, temporary employees if they're jointly employed and managed by your employer. And the factors that attorneys would want to consider in analyzing this question are the employees under the common management of your employer? Is there an interrelation or overlap between their operations? Is there a central control over labor and employee relations? And is there a degree of ownership or financial control that is shared between multiple entities? Gray area number 4, please, is how does the employee request benefits from the employer? The EFMLA and EPSLA do not say whether requests have to be made in writing, and if so, what the request must include. So we would, generally encourage people to follow what the law has developed and what the regulations provide for under the Family Medical Leave Act, which is, employees should, first of all, it's the employee's burden or responsibility to give notice to the employer of their need for leave and requests for benefits. Under the current interpretation of the law in the Sixth Circuit, there's no magic words that need to be used, but it must be sufficient to reasonably apprise the employer of the request to take time off for a serious health condition, or in this instance, a condition that qualifies you under one of the criteria under the new act. The employee does not have to use the words FMLA, EFMLA, or Paid Sick Leave Act, but it has to be specific enough that the employer knows that their obligations are invoked. And this is a case-by-case, fact-intensive inquiry. And for right now, for purposes of getting legal advice, I think we default to what the standards have been for many years under the FMLA. Gray area numbers 5 and 6, please. The new laws do not allow employers to require that you use your paid sick time or accrued PTO as a precondition for getting the new benefits. But there's some overlap here in a relationship between accrued PTO and sick time that people are going to get tripped up on and probably need to know about. If the employee is using sick leave or paid leave of any kind for another reason, and then they develop a new need for a COVID-19 related reason, then they can use the new form of paid leave or emergency family leave without having those run concurrently. But we have to be mindful to advise employees that their annual maximum leave time is still only 12 weeks. If the employee requests the emergency family leave benefit under the EFMLA to take care of a child who is out of their daycare or school situation, then the employee has the option to use their PTO time so that they continue being paid during the initial 10-day period of unpaid leave before the paid leave time kicks in. As for the timing of paid leave benefits, we don't know. The law does not expressly say that the benefit must be paid in the next most immediate paycheck or pay cycle, but we anticipate that employers should try to do that. It'd be the next pay period after the leave is improved. And we're going to have to wait for guidance and experience to show us what the remedies are if the employee delays payment. That would probably trigger the civil right of action provisions under the statute if there's just a complete failure to pay. Next gray area, please. Lastly, Michael spoke about the exemption that's available to employers who have less than 50 employees. The Secretary of Labor has the authority to decide whether or not an employer can be exempted under the law. The standard seems to be high based on the language of the law and the guidance, which means the business would have the burden of showing that paying the benefit or providing the leave would jeopardize the viability of the business as a going concern. We don't know what the quantum of proof is going to be, what the standard or burden is going to be on the employer. The Department of Labor has said it will issue additional guidance on this question sometime in April. We're still waiting for that. In the meantime, in the guidance that has been issued, the Department of Labor has expressly told employers not to send it any materials about making those requests. So, you know, that leaves small employers in a real tough position, and they should probably proceed as if they are required to pay under the law. Otherwise, they could face some substantial penalties for non-compliance until they go through a process. We also don't know, for example, if an employee loses benefits because of this exemption, what will happen? Will they have to pay back benefits that were provisionally paid? Is there going to be an administrative process in place where the employee can contest or dispute or appeal the determination that it would exempt the employer? This is an area that could get very complicated and very messy for small employers very fast. Next slide, please. Your health insurance, if under the old FMLA, the traditional FMLA, an employer is required to continue group health insurance coverage as if you had continued to work. You are, under the old FMLA, required to make normal contributions to the cost of the health insurance premiums. Nothing in the new law changes that. And if you're on paid sick leave or emergency family leave, you do not sever or terminate employment. So if you follow those things through, there's a logical case to be made that your health insurance benefits should continue the way that they would under the old FMLA. The caveat for that is that if you lose your job or completely, or if you're laid off, you may lose your health insurance benefits depending on the specific circumstances. But strictly speaking, your use of EFMLA time or receipt of paid sick benefits should not incur a loss of health insurance coverage. I think that does it for our gray areas.
Okay, before going to Beth, let me call on Heidi Sharp.
We'll take over next.
From Sharp Law to talk about what happens. I'd like Heidi to focus on what happens if you're an employee and the employer says you're an essential worker for my business and you think otherwise. How do you handle that? Go ahead, Heidi.
Oh, so what we're looking at here with essential employees, of course, we know that the governor issued a stay home, stay safe order. And this exempted any employers who were considered essential to maintain life, is what she said. And she indicated that those, of course, some of those things are obvious. Hospitals, medical providers, police, fire, things of that nature. But what we're having now is what I've encountered is a whole number of employers who've informed their employees that they believe that they're essential for sometimes what seems like good reasons and sometimes what seems like they are not. When we're taking a look at that, you have to determine in what situation are they putting the employee. So for example, I had a contact from a potential who indicated that their employer wanted them to drive and provide residential drop-off of building materials, windows and other things. And he said that he believed that they were essential because of their ability to build and maintain these construction industry. I don't believe that that would apply under the governor's particular order, especially since she clarified later last week that that type of industry should not continue. When that happens, you have the right as an employee to indicate to your employer that you do not feel comfortable violating the law. In this case, the law would be the governor's stay home, stay safe order. If your employer took adverse action against you, so that would be something like a termination, a discipline, a demotion, a reduction in pay, something that affects your ability to maintain your employment, because you objected to violating the law, you may have a cause of action. You also would have the right to report that employer if you chose to do so. The Attorney General has provided some guidance in this area. The Attorney General has indicated that they do not necessarily want employees or the general public to report violations of the Stay Home, Stay Safe order to the Attorney General, but they've indicated that it should be reported to the appropriate authorities. So that may be your local sheriff's office or the Michigan State Police, depending on the jurisdiction in which you're in. Further, what has happened is if you do have a employer who maintains staying open as an essential employee, it is a misdemeanor and they could be subject to being ticketed for staying open. If they're a essential employer and we're in a position where they are an essential employer. So for example, there was some contact from some persons who worked in the office of a nursing home. Well, that nursing home does have to stay open. Of course, they're essential to maintain the life of their residents. And the employee indicated that they didn't believe that their job was essential at that time, but their employer wants them to maintain employment for a number of reasons. One, because they may need other employees to fill in as employees are unable to work due to some of the reasons we talked about here today. And because she has the ability to be trained in other areas, they wanted her to maintain her employment in the areas in the office. What happens then is when you have an essential employers open, you do still have rights to protection. First, if you might have an underlying health condition that you believe would qualify you for a disability under the Americans with Disabilities Act, you may ask for an accommodation, which could be a number of things. Maybe a job transfer, personal protection equipment, which could keep you from being possibly infected or having something that you came in contact with, or a number of other things, maybe even a leave of absence during this time. If you don't have an underlying health condition, but you want to just ensure that you receive all of the most appropriate equipment to maintain your own personal protection, you can do so. If you're in a position in which you believe your employer has not provided that equipment, you of course have the right to make contact with the MIOSHA, which you can call them for information or to file a complaint if you believe your employer hasn't provided personal protection equipment. Their most direct contact number is 1-800-866-4674. If you believe that your employer, it's more appropriate to call OSHA, which is the federal protection, and that number is 1-800-321-6742. Those types of situations may come into play if you believe that your employer has placed you in a situation in which it is so hazardous you cannot continue to work. But there's very specific situations in which you may not be able to continue to work. The first thing you should do in those situations is make your employer aware. Make sure they are aware of what your concerns are. Ask for the personal protection equipment. So those are the things like a mask, gloves, hand sanitizer, soap and water, disinfectant, things that you can have in your workspace when you continue to work as an essential employee. But any employers who continue to maintain that they're essential and they are not, you of course have that right to report them and you can determine what's the best course. One of the things that Rachel said earlier is to be reasonable. If you believe that your employer maintains employment and has asked you to come to work, they're not essential and they should not be open, you're free to ask for a leave of absence. In those types of situations, if you then apply for unemployment, the steps that she spoke about would apply, and the unemployment could determine if it was reasonable at that time for you to ask for that leave of absence or to leave your employment. If your employer was deemed not to have been an essential employer and they continue to stay open or require you to come to work, I think that that would be a situation where you'd likely be able to receive unemployment benefits. But again, those are going to be case-by-case, fact-specific situations.
Thanks, Heidi. Beth, you want to wrap up with strategy?
Sure. Can we? Okay. And a lot of this has been covered in other people's presentations, but we should recognize that these were some statutes and executive orders that were passed quickly in a environment to try and help businesses and individuals. And there was a lot of unanticipated circumstances which will have to be dealt with as time moves on. So for requests to the employer, for leave, a question as to whether your position is essential or even the employer work is essential, make the request, ask the questions in writing, and be as specific as possible, both to create a record for the future and so everybody can try and stay on the same page as to what's being asked and what's needed in any situation. Work with your coworkers. Network with them, talk to them, approach the employer together. There's always power in numbers. As everybody before me has said, this is a ever-changing environment and situation and quickly evolving. The regulations and guidelines are still being drafted, and new guidelines will likely be issued on a daily basis for a while. So you should check sources of information daily, particularly from the Department of Labor. Both take this opportunity to educate employers. You know, this is a time where both the employer and the employee is a little bit in the same position. Everybody's struggling, trying to figure out how to navigate this environment and this new normal. Help remind employers that they're eligible for loans and advances to help meet payroll and other obligations so that they can keep their businesses operating and continue to pay you. In addition, you can remind them or educate them that they're eligible for tax credits for payments that are made to employees under these new laws. When you are trying to decide what to do for your own employment or for your client, remember that many of these new laws can be combined and used together for the best effect, concurrently or sequentially, but you can use more than one of them. It's not a, pick one approach. And finally, we've talked about that some of these laws provide options for potential litigation, but that's down the road and will only provide relief in the future and should be considered only as a last resort. You should try and work with your employer to get relief now when it's needed most, not 18 months down the line after a lawsuit. So other than questions that people have, I think that covers our presentation.
Thanks, Beth. So you have a few minutes. Is there anyone from the media that's on this call that wants to pose a question from the media?
I don't have any. The only question I have right now is from it's for a school district employee. It's for school district employees' daily subs that are usually not eligible for unemployment. If they receive a letter of reasonable assurance, would they be eligible for unemployment now due to the mandatory shutdown of schools?
Rachel?
I think so. And I think based on the fact that they're not reasonably assured at this point, they're not working. So I think so. I think that's to be seen still, but I think that they should apply and let the agency sort that out.
Then,
Are there any employer advocates on the call? Attorneys who represent employers that can share some insight? Nobody fitting that category? So let me point out that there are substantial tax credits that are made available to small businesses who comply with the federal law. And many of the loan opportunities are positioned with your local banks. Banks are beginning to develop guidelines. So if you're a small business owner, or if you work for a small business owner, be sure to alert them and say, look, if you pay me, you're going to get reimbursed. And basically the government is going to pay for my sick leave if you go through some simple processes with the government in terms of securing tax credits, interest-free loans, and even outright grants. So some of the money that has been set aside is just to give away to employers who are compliant with the federal law. So you need to, if you're an employee, you need to mention that and encourage your employer to investigate what options they have made they came about as part of the $2 trillion stimulus package. Are there any other questions?
Yeah, I've got two questions from Facebook, Mike.
Okay.
Michael, first one is, what about college students who are doing jobs at their college? Are they eligible for any benefits?
Well, yes. I mean, if they would definitely qualify. Well, depending on the size of the college, I guess Emergency Paid Sick Leave Act only applies to employers of less than 500. So if the college has less than 500 employees, which some colleges are small, probably might fit. I think you definitely would be eligible for paid leave, and it's possible that you may even be eligible for emergency family medical leave, depending on your situation.
Okay, and then the last question I have from Facebook, actually there might be some more here, hold on. This is a more personal story, but basically just to reiterate, can a person be fired for not going in to an unsafe work environment? I think you guys have covered this, but just to reiterate it, if they view the work as unsafe, what protections do they have?
Yeah, well, employees can always be fired. The question is it legal or not? If they get terminated for that reason, I think they're eligible for unemployment. Would you agree?
Yeah, they definitely would be able to get unemployment benefits from there, because it's not, if you're being fired, the question that the agency is going to look at is whether or not you intentionally disregarded the employer's interest, and you not going into work being afraid of for your health concerns would not be substantially against your employer's interest there. However, I still would recommend, before you don't show up to work, you need to tell your employer why you're concerned, try to work it out with them, and get see if there's anything that can be done on that front. And make sure you stay in constant communication with your employer, because not showing up to work and not calling in for a substantial amount of time, especially three days in a row, would potentially be disqualifying for unemployment.
Okay. All right, so a clarification on the college one. It says, my son works at a community college. He is a student employee. Does he qualify for unemployment? The college told him that they're not able to lay anyone off, but the college is currently closed, so he's not actually working.
So he's on like an unpaid leave, essentially?
Seems like that's the case.
Then I think you would be able to apply right now. If the employer has placed you on a leave, and then you are entitled to benefits per the statute if you're not earning any money.
And then I think this is the last one. I'll just double check on both platforms we're using. There are teachers that work at a restaurant. Are they able to apply for unemployment for lost restaurant wages, even though they're still making a salary from being a teacher?
So that is a more complicated question. It depends on how much they're earning. So if the amount that they're still earning as a teacher is more than 1.5 times their weekly benefit amount, then they're likely not going to be eligible. They can apply, but you might not be eligible for any of the weeks if you are earning more than 1.5 times 362.
That raises another point. I mean, there's nothing in the law that explains how tipped workers are to be treated. That's obviously something that's going to would fall into a gray area, is how do we calculate the wages for tipped workers, and what are the eligibility standards for tipped workers? That's to be determined later on, I think.
And I think that one good thing about the federal expansions here is that sometimes tipped workers, like servers, might not have earned enough in their benefit year in their typical wages, and not all of their tips may or may not all be reported. Who knows? And so they don't appear to have earned enough monetarily, but because of the pandemic unemployment assistance, they're now covered under, they would be caught under that part of the security net. So it's possible that they would still be able to get some of the federal expansions of unemployment right now.
It sounds like that would also, we had a question asked about how would pay be determined for commission sales folks. It sounds like a similar kind of problem.
For unemployment purposes, is that the question?
Yeah, for commission sales.
Well, right. So if there are no, it's based on what your earnings were for the prior 18 months, is how it's calculated. And so, but if you are earning any future commissions and you have filed for unemployment benefits, but a commission comes in, you have to report that as earned income, because that could limit your eligibility for a certain week.
And for paid sick leave benefits, the law is silent and the guidelines are silent on how commission employees have their paid sick leave benefit calculated. The Department of Labor will probably issue guidance on that. The guidance should be patterned on the Fair Labor Standards Act, which does include commissions in calculating what's called the employee's regular rate of pay. So if it plays out according to those existing regulations, which would be the most logical way to do it, then your commissions will be used as a factor to determine what your paid sick leave wage ought to be.
Okay,
Yeah, and let me point out that under the emergency paid sick leave statute, they adopted the remedies from the Fair Labor Standards Act, which includes a $10,000 penalty per violation against employers who willfully violate the law, as well as if there's a lawsuit, you can get double your lost benefits as a remedy plus attorney fees. So, employers should be very careful about denying claims because they do so at their peril. And we're hopeful it never gets to that point, but the law does have some teeth in it, and small employers need to be mindful of that.
here's another question. The earning threshold for low income was stated by Rachel as $4,000 over 2 quarters. This is a change to the current $2,800 in 1 quarter, with 1.5 times that in 5 quarters.
I think it's a question about how monetary eligibility is calculated. There are a couple different formulas that are used. And so typically they look at the past 5 quarters. There's 1 quarter, at least in 1 quarter, you have to have earned a certain amount. And I believe that amount is slightly less than $4,000 right now. And then your total for that 5 quarters has to be, the total amount has to be at least 1.5 times your highest wage quarter. It's a complicated formula. There's also a couple alternative formulas that I can't recite to you offhand. But if someone is not monetarily eligible for unemployment benefits right now through the state of Michigan, they still might be qualified under the pandemic unemployment assistance from the federal government. So I'm not sure if I fully answered the question, but I didn't quite understand it. So
I think that's helpful. And then just, we've been getting a lot of questions about 1099 employees. I know there's been some changes federally. Can any of you speak on what 1099 or independent contractors should be doing right now with the federal changes? Is anyone comfortable answering that question?
So as far as unemployment goes, the pandemic unemployment assistance part of the federal law will cover them now. So they should apply for unemployment benefits with the agency. I think right now the agency is still adjusting to be able to account for all of these new changes. This is the pandemic unemployment assistance program is similar to disaster unemployment assistance, which is something that Michigan has issued before. So they have a similar claims process for that. There'll be more information probably issued by the agency later this week about how to apply for it. And so you can apply now, but I think that there'll be a clear way to apply later in the week.
Okay. All right. Well, that's all the questions we have. Michael, do you want to just briefly talk about your firm and how people can reach out to you guys? What your website is?
Well, we, our firm is available to answer inquiries. Is Pitt, McGee, Palmer, and Rivers, and the phone number is 248-398-9800. You can Google us, and also the State Bar of Michigan is setting up a rapid response group of lawyers who will be able to help citizens of the state of Michigan deal with these types of issues. And so watch the State Bar of Michigan website, because there'll be referral sources there. We also have Heidi. You want to give your contact information?
Sure. My firm is the Sharp Firm. We're located in Clinton Township. Our phone number is 586-226-2627. We're at www.sharpfirmlaw.com.
And also the Workers' Rights Clinic at the University of Michigan, that's where I'm at. We handle unemployment issues and especially helping people obtain their benefits, especially if you've been denied for some reason. You can give us a call at 734-936-2000. Due to the massive spike of unemployment in the last couple of weeks, we are receiving many calls right now. So we will do our best to give you a call back as soon as possible. But please, we ask that it might be up to 3 days.
All right. Well, thank you, panelists, for your time and your insight. We will have this presentation has been recorded. We'll post it online and on the Michigan Association for Justice website at michiganjustice.org. It'll also be available on our Facebook page. Thank you all for coming, and have a great day.
Thanks, everyone.